Have you been sued with a debt collection lawsuit and now you need to file an answer, but you're not even sure what an answer is? In this video, I'm going to talk to you about what an answer is and why it's so vital that you file it with the court. Hi, my name is John Skiba and I'm an attorney in Arizona and I help people with their debt problems. If you've been sued by a debt collector, you have 20 calendar days to file a written response with the court to the allegations that they have in the complaint. Now, when you got served with the lawsuit, you got served with two documents, the summons and the complaint. If you take a look at the complaint, that's where the list of allegations are, where they're claiming that maybe you owe a certain amount of money or that you entered into a contract with that particular debt collector. The answer is merely you going through each of those paragraphs and responding paragraph by paragraph to the allegations of the plaintiff. You're simply saying whether you admit or deny the allegations that are in the lawsuit. One thing that an answer is it's not your opportunity to tell your side of the story. Often I meet with people in my office who have represented themselves in a lawsuit, and when I see the answer that they filed with the court, it's a great big long thing from day one of the contract to right up through the time when the lawsuit was filed. This is not your time to tell the court your side of the story. That day will come, but the answer is not the time to do it. And in fact, you can even harm your case by going into a lot of detail at this point. So the first part of the answer is you simply admitting or denying the allegations that the plaintiff has in their complaint against you. The second part is you have to list any affirmative defenses that you have. Now, affirmative defenses are a little bit tricky. The best way to think of an affirmative defense is kind of in the criminal setting. In a criminal setting, you could be charged with murder, and you may say, it's right, I did kill that person, but I have a defense, self-defense. I was protecting myself. One of the most common affirmative defenses is the statute of limitations, where you are saying essentially, even if everything that the plaintiff is saying is true, the statute of limitations has expired and they can no longer sue me on this debt. Affirmative defenses are important because if you don't bring them in your answer, it's possible that you waive them down the road. So just as a recap, the two parts of the answer, the first part is just simply admitting or denying the allegations that the plaintiff has against you, and two, listing any affirmative defenses that you have. When you go down to the courthouse to file your answer, it's important to take an original and 2 copies. File the original with the court and have the clerk timestamp the other 2 copies, one for your records and one to mail to the opposing party. A lot of people think the court's going to let the opposing party know that you filed an answer. They're not going to do it. That's something that you're going to have to do yourself. If you have questions on filing an answer or if you need some help doing so, give me a call. I do this all day long. I'm happy to help you. Again, my name is John Skiba. I'm an attorney in Arizona and I help people with their debt problems. Thanks for watching.